All right, Bill, I think we're going to get going. I think we've done our best to allow people to adjust to the unfortunate change that we had to send out late in the game. So again, thanks so much, everyone, for your interest in the webinar today. We're going to be talking about the PPP Flexibility Act of 2020, which recently was signed into law by the president and released late last week. On the call today with me is my partner in crime, Bill Claffey. We've been doing a number of these webinars together. Bill's a partner in our tax department, and will be leading us through most of the slides today with my assistance. Again, my name is Frank Milone. I'm one of the founding partners of FML. FML is a full-service firm. We're headquartered in Glastonbury, Connecticut. We have a fully staffed office out in Enfield, Connecticut, as well as satellite offices in New Haven and Stamford. The firm has over 13 partners and over 80 employees. Very strong player here in the Connecticut region and in the Northeast in general, working with a lot of different sorts of companies, from traditional middle market to highly high growth started companies and funded companies, as well as we're PCAOB registered and working with public companies. So I have a lot of really good experience. And again, my background is I'm one of the founding partners, and I help run the audit practice here at FML. And with me today is Bill Claffey. Bill and I co-chair the COVID task force within the FML offices, and as part of what we're doing within that task force is we're assisting our clients, but also trying to gain a knowledge of all of the information relating to what has now become mostly the Paycheck Protection Program and the Act and the related guidance that has come out. We've tried our best to disseminate that guidance through our social media, through our website, which we have a COVID dedicated website, what we encourage you to go to, and then also through these webinars. And Bill and I have presented a number of these webinars, and this one is focused on the Flexibility Act, which will obviously change the game for a lot of folks. And so let's get to it. And at this point, I will turn it over to Bill to introduce himself a little bit more and get us going down the road of the webinar. Thanks again, Bill.
Great, thanks, Frank. As Frank mentioned, I'm a partner at FML. I'm on the tax side. I have a legal background, so a little bit of a black sheep within the firm, but I think it makes for a nice, ensemble for us to look at things from different perspectives. I focus on state and local issues, but also on a lot of tax policy and tax controversy matters. So, as we were putting together our task force, it certainly made sense for me to be on the panel, as well as Frank and many others. So let's jump right into it. This has been an unhidden secret for a couple weeks now with this Paycheck Protection Program Flexibility Act. It was bouncing around the House. The Senate didn't appear to agree with many of the provisions in the Flexibility Act. However, they did pass it as drafted, and the president signed it as drafted. Our understanding is that there may be some technical corrections that come out with respect to the Flexibility Act, but we don't know exactly where that's going. What we do know, though, is that the Treasury Department had a joint meeting with the SBA. I'm assuming it was yesterday, regarding the publication of additional guidance. As you know, and if you've been following us, the SBA has been they've been providing what they call interim rules and FAQs with regard to the PPP program. I guess this new guidance is going to be, like I said, in conjunction with the Treasury Department. So it'll be interesting to see kind of how that may change their tact in some regard. But that should be forthcoming soon. Hopefully it is. Obviously, there's going to be a need for a new PPP application. I think, Frank, our last webinar was following the PPP application that came out, and we talked about a lot of new concepts that were introduced in that application. Well, that's going to have to all be changed. So bill was signed into law on June 3rd. We note here, we're going to go through all these bullets, but just at a high level, we're talking about a pretty significant shift in the way this thing has been viewed and administered. And, a lot of folks are already toward the tail end of their 8-week period, and now they get thrown this curveball. But, we've got a real big shift here with regard to the covered period, the 75%, 25% test that, again, if you've heard us talk, that was never in the CARES Act. That was an SBA regulatory provision. The safe harbor dates, which obviously we're going to get into all this in more detail. There's some new safe harbor provisions that will certainly provide some relief to, certainly various types of businesses, like in the restaurant and the gyms and other businesses that have really been kind of shut down for the last few months. So that those will help those and may help some of you folks on the call here as well. Then you've got the deferral of the loan payout, and then some provisions with regard to employer taxes. We'll say it here. We're going to say it throughout. We've got a new game here. We've got a new set of facts, and so as you go through, and like I said, many of you may be at the tail end of this. You're going to have to kind of reanalyze your facts and determine where do you sit versus the old rules, and where kind of we sit with the new rules, and determine what makes most sense for you as a business. Okay, so this is the big one. They've extended the covered period to 24 weeks or December 31st, whichever is earlier. Obviously, that's a significant shift. I mean, we've been operating under the 8-week provision. Early on, there was a lot of questions regarding the cost or the cash versus accrual, and is it going to be 8 weeks? Can you extend that beyond the 8 weeks, or is it even more limited to a 6 or a 7-week period, because the cost had to be paid and incurred? And so as we went through that, we were given little snippets of guidance, and then the application came out and basically said, no, we're going to let you take both. We're going to take you the payments that you made, and we're going to let you take any costs that are earned or incurred during the covered period. Well, what did that do? That really extended the 8-week period to really potentially, and depending on if you were a biweekly payroll payer or a weekly or twice a month, it extended that period already at 8 weeks to possibly 9 and possibly even 10 weeks. Well, now we've got this, which says, okay, we're going to give you 24 weeks to spend this money. And, like I said, for a lot of companies that are at the tail end of this, that's great. There's some flexibility here, but many folks are not going to need that flexibility because of the cash versus accrual concept that was clarified in the application. But if you do, that option is available to you. So you're going to start arguably with your loan disbursement date. That wasn't directly addressed, but you're going to start with your loan disbursement date, and you're going to have 24 weeks to spend money on the same costs: payroll, the ancillary payroll costs, rent, utilities, and your mortgage interest. Again, many folks may be at a point where they only need 9 weeks. They only need 10 weeks. That 24-week period, if we go to bullet 2 here, that you can still elect as a borrower to use an 8-week covered period. And that I'm assuming, Frank, I don't know if you've heard any different, but I'm assuming that's gonna be some sort of an election that comes forth on the revised PPP forgiveness application.
Yeah, it's a great question, Bill. I mean, we have not seen or heard of anything as to how you elect the 8-week versus the 24-week. We do know that new loans won't have that option, right? New loans that are entered into will automatically default to the 24-week, but it has to be something that's going to come out in the form of a new application. I would agree, check the box or something of that nature.
Yeah. So the other thing that, maybe the joint SBA Treasury guidance will answer this question. Frank and I debated that this morning is, if you choose the 24-week option, but you kind of finish spending your PPP funds in week 11, can you apply for forgiveness at that period? Right now, as the statute is drafted, my answer would be absolutely not. However, as we've gone through this process, the SBA is not afraid to issue guidance that's in some respects a little bit contradictory to the statute, and clearly it's kind of at least if it's not contradictory, it's a jump from where the statute was. So as of right now, that's kind of what we're operating under. If you're going to have this option to choose either the 8-week or the 20 or the 24-week, and that'll probably be made on the application.
Hey, Bill, it's interesting as I'm reading questions that are coming in from the audience, and it's great. We have a lot of people that are participating, and it's really helpful. People are continuously asking, we had this magical 15,385, right? Which was the 100,000 divided by the 52 times 8, does that automatically now increase to $46,154? I mean, and that question has come up a number of times, right? Which is the same math times 24. Those are the sorts of questions that you and I were starting to debate on the pre-call, which is, how is all of this going to now be recommunicated in the form of, here's what the expectation is on the salary limits and on the tracking of the employee information, on the tracking of all the safe harbor information that I know we haven't gotten into yet. But as much as this has been a welcome to relief for a very strong group of businesses that haven't been able to get going, I think it also creates a lot of angst, right, and anxiousness into companies that have been operating and kind of managing this process in a manner that's going to hopefully max themselves out, in a week or two. And now they've got all of these new questions, and we don't know where to start on a lot of them, question-wise.
Yeah, I mean, so let's take a step back. If any of the folks in the audience have read the actual act itself, you'll see that, unlike the CARES Act, which is for the most part kind of an initial draft of legislation, there are references back to the Small Business Act. The Flexibility Act is really a bunch of references back to the CARES Act, and what it does is it strikes certain terms and amends certain terms. And so as you're going through that, it amends the covered period to be 24 weeks. It strikes certain dates, which we're going to talk about in a little bit regarding safe harbors. So in the nature of the way that it's written, I don't think we can assume, and I wouldn't assume that you're going to be able to increase those salaries from 15,385, to whatever that number was, 46,000 something and change. Yep. Yep. Because it's not that the way the Flexibility Act was drafted, it didn't revise those terms. So unfortunately, that's just the way it is. Now, where you could get benefit is if you had an employee that, and it's all going to depend on where the borrower is from a spending perspective. But let's say you had an employee that made $50,000, so you've roughly paid that employee, $7,600 or somewhere in that range during the covered period, and you have additional funds that you can expend. If you opt for the 24-week period, you can increase that and use the funds to increase that employee's compensation up to the 15,385 kind of magic number. I don't know how many companies are going to be in that position. It's probably going to come down to timing as to when you actually receive your loan. Because if you were listening to us or you were listening to, other advisors out there, we were just reading the act itself. You were kind of under this race to try and spend your money. And while the Flexibility Act has some great provisions, it's really late to the game in my view.
Yeah, I mean, Bill, there's a lot of, back and forth here, but, people are asking, when would the 8-week period ever make sense if you have 24 weeks to now spend your money? Yep. I think most people are taking the position that if you have more time, it's better, right? Yeah. I all I would say to you is it's really hard to get into a lot of specifics, but what I would say is if you've been operating in a scenario where you've basically pretty much maxed out your loan usage in over an 8-week plus period, if you're using the accrual concepts, and now you now need to go back to, and Bill is mentioning it in this slide, you've got all of these safe harbor provisions that were used to be a part of the process as of, June 30th, and now they need to be measured, as part of a December 31st. You could have a scenario where you're not relying on safe harbor. You could be in a position where you've maxed out your loan just based upon your individual facts and circumstances, and you have the ability to go through an 8-week process, maximize, and move on. What we've told people is, until there's clarification, especially on the safe harbor concepts, if you're going into a 24-week process, you may need to now maintain employee levels, salary levels over 24 weeks, which for some businesses may be more risk than it's worth in a scenario of going over a 24-week period to maximize forgiveness or usage in a manner that may also expose them to losing forgiveness if they go under the new safe harbor rules. So
yeah, and that's exactly it, Frank. And that's really these two of the last 3 bullets there, is that that maintenance of your FTEs for a 24-week period. That's going to be tricky. Now, maybe the SBA comes out with some guidance, and maybe they come out with something that gives some eases the burden there. But absent that, you're going to have this this count that you're going to have over 24 weeks. And if you've already spent 90% of your proceeds to maintain your employees, right? You maintained them during the 8-week period. You're trying to squeak out that last couple, 7,500 grand of your loan, or 10% of your loan. But now you got to keep those people for another 16 weeks. And from a business perspective, you may not be able to. And you were able to during the 8-week period because you had funds to pay them. But for the additional 24 weeks, those funds may or may not be there. And if it's if there's uncertainty there, then it may benefit you. And again, go right back to our first slide. Everyone needs to analyze their situation, but it may benefit you to say, all right, I'd rather spend less, know what my FTE count is for my numerator, and then move on.
Yep, I agree. I think it really, we should continue to work through the slides, because I think at some point people are going to start realizing that it may not be as easy as just saying, hey, I have 20 more weeks to, 16, 20, 18 more weeks to spend my money. It comes with other complications relating to safe harbors, employee levels, and for some businesses, if you've applied for a loan and you weren't able to get your business going again because of state regulations and other regulations, and the business couldn't be opened, extending the loan makes a lot of sense, because people can now use the money to pay employees over a longer period of time. But for other businesses that have been full go since getting the PPP loan, it's not as simple as just saying, hey, let's just run it out for 24 weeks and call it a day. I think there's a lot more that needs to just be projected. And most of us are telling clients, finish out your 8-week projection, and then finish out your 20 and go out and do your 24-week projection, and think about what benefit you're going to get over those additional weeks, and also understand what are the variables that need to be considered in the form of the safe harbors and other employee counts, salaries, and other aspects. So.
Okay, so this is kind of one of the second important points that come through the Flexibility Act. So again, if you've been following this and you have your loan and you've been listening to us or any other folks, you know about this June 30th safe harbor. That was always something that everybody knew about. There was a lot of question as to what did it actually mean. It seemed like it could be very manipulated, and but it is what it is, and the statute is what it is. And so just to kind of quickly take a step back, those safe harbors were if you had a reduction in your employees between February 15th and April 26th, and then continued that reduction during your covered period, you could, as long as you got your employment levels by June 30th up to the numbers you had on February 15th, then you qualified for this safe harbor. And that safe harbor, the way that it was written in the act, was basically said, disregard the FTE reduction calculation, disregard the salary reduction that you may have had if you brought salary back up to the amount, the salary or hourly wage as of February 15th of this year. So, I've spoken to a lot of folks, a lot of companies that are, we're looking to use that safe harbor and already have a plan in place in terms of bringing some employees back for the June 30th payroll period. Well, that's all been erased. That date is moved up to December 31st of 2020. And that does not matter whether you have whether you elect an 8-week period, at least as it's written right now, an 8-week period or a 24-week period. Now, Frank and I, you and I debated that this morning as well. Seems illogical to do that, right? But that's the way it's written.
Yeah, I think that was my point, Bill. I mean, right now, it seems to be a disconnect. If you choose the 8-week period because you have the election to do so, and just to be clear, I think there's a question out there. An old loan holder before this Flexibility Act came out can still choose an 8-week period. We don't know how. We don't know what the process will be, but you definitely still have the ability to do that. If you're going into a new loan process, you don't. But if you choose that 8-week period and now you've got to run out your safe harbor provisions to December 31st, it just seems like the benefit of staying in an 8-week period at that point without being able to manage your employees to those 8-week periods seems to be a little bit of a disconnect to me. And just doesn't, again, hopefully it will be clarified soon, because we have, a number of our companies, clients are coming up to the end of the 8-week period. They want to understand how to manage it. So.
Yeah, and I think we make the point a little bit later in the slides, but another piece of the Flexibility Act is this, this requirement to apply for loan forgiveness within 10 months of your loan disbursement date. And obviously, if you choose a 24-week period, that it starts to get closer to that 10-month period. But that 10-month period is going to get everybody into 2021. So it would, now it doesn't say whether you're required to wait 10 months. Certainly we're going to be required to wait for the updated PPP application to come out. But it sounds like you can wait for a 10-month period. And so you may want to do that because there's other deferral concepts here with regard to loan payout.
Hey, Bill, just to clarify, and, just as an example, it's a great question posted in regards to the exact point that we were making on individually. Companies need to go through and analyze this on their own. I mean, someone talking about the fact that we're at a full FTE level at the end of the 8-week period, but we haven't expended all of our PPP fundings. They want to go 24 weeks, but they don't have the money to pay everybody for the full 24 weeks. So now they're making an operating decision here, right? They're making an operating decision as to what levels of employees do I need to hold to manage my business in an economically responsible way, in a financially responsible way. Should I be laying people off and then bringing them back to maximize the ability to use the funding and all of the forgiveness concepts that are now layered into it? Those are decisions that can't be made unless you project out information. But also, Bill and I will reiterate this over and over again. Understanding the value of the forgiveness concepts. Believe me, FML has a PPP loan as well. But the other thing to understand is you've got to manage your business in a manner that is, financially encompassing all of the concepts that you need to run your business, not just maximizing forgiveness of the loan. And it's something that you need to work with your advisors on, not only to project out 8 weeks, 24 weeks, but also understand the variability that you need to manage your business in a way that's going to get you through what is still an unknown, summer and fall season for most businesses entering into a winter. We just don't know what we don't know. And so I think it's doing it in a most responsible but also inclusive manner of all the facts and circumstances is really critical as you think this through. So.
Okay, so moving on. So the Flexibility Act introduces some new safe harbors, right? So we had the safe harbors related to FTE count, June 30. Now we're at December 31st. You got the safe harbor related to salary hourly reduction, right? And we've gone through those concepts in the past. There were some other, I don't know if you'd call them safe harbors, but you had some other provisions with regard to FTE reduction. If you had to terminate an employee for cause, if an employee voluntarily resigned or voluntarily requested a reduction of hours, I guess you could consider those safe harbors as well. But now we've got a new set of safe harbors, which they label as employee availability. And so those safe harbors, so the way the statute is presented, they say that the proportional reduction in FTE will be disregarded to some extent if you have an inability to rehire a former employee. Now that's pretty similar to one of the previous safe harbors, but I think this one's actually a little bit broader, right? So if you've tried to rehire a former employee and you can't, in the previous one you had to have a written documented offer and a written rejection letter. The new act doesn't necessarily state that. Probably be safe to do that, but it just says if you have an inability to rehire a former employee, then the proportional FTE reduction related to that won't be counted. Inability to hire a similarly qualified employee. So, I know a lot of folks are, just depending on your business and your industry and your circumstances, but you may not be able to hire not only your former employee, but even someone who's got a similar skill set. If you can document that and you can show a good faith effort, and that's kind of the last bullet there, that you've gone through that process, then those FTE reductions won't count in your calculation. And then the third bullet here is an inability to return to pre-COVID, which they define as February 15th, business activity levels due to all these various requirements that we're all seeing on the news, right, regarding social distancing and safety requirements. And, I don't know exactly the intent of this provision. I would imagine it had something to do with the restaurant industry, because clearly they're going to be someone that would be impacted by this. But if your business has certain restrictions that are and certain compliance requirements that are issued, and it's got to be from the Health and Human Services Department, the Centers for Disease Control, and OSHA, if you've got limitations that are placed on your business and your employment levels because of those, then any reduction in FTE related to those compliance requirements would not hurt you in your FTE count. So those will be interesting. I mean, Frank, you and I talked a little bit about this. I think this is really ripe for certainly additional guidance, but certainly a lot of interpretation as well, because you get into some pretty, relatively subjective. I mean, you're going to have guidance coming out from the CDC and from the Health and Human Services, but how far that extends and exactly who that ends up impacting could be something that could be ripe for debate, right? I mean, it looks like there's good faith requirement, but it didn't tell you to kind of look at a checklist from the CDC, and if you check the box, then then your FTE reduction is not reduced.
Yeah, one of the things we talked about was, state requirements, don't really get mentioned here.
Yep.
So if your state has restrictions that are more stringent or impact you in a manner that's maybe different than how some of the guidance that's been issued by the outlined agencies, does that also allow you to claim this safe harbor? Just for example, definitely. In the level of documentation that you're actually going to be able to manage and put together, and some of this seems a little bit less substantive, I guess, in nature. And so you're going to really need to do your own documentation as to how you're going to prove, if challenged during an audit process, why you excluded certain people from your reduction of forgiveness concepts on your FTEs. So.
Yeah, and certainly documenting an inability to hire a similarly qualified employee, and that's not. There's no objective bright line test that you can place there.
Yep.
It's going to be gathering your evidence. What did you do? How did you do it? Who did you interview?
Yep.
You have to gather all that information. All these new safe harbors, by the way, run from February 15th to December 31st, right? So you're going through that analysis kind of throughout that period.
Yep. Hey, Bill, before we move on, a couple things. So, one of the questions came in asking if we're saying we don't know if the 15,385 is increased with a 24-week extension. I think we're not saying that it's not increased. What we're saying is you can't just automatically assume it's going to be the same calculation. But I would say, Bill, unless you disagree, it's probably in line with that same concept, right, of, taking that same math and extending it out over that period.
Make sure I understand the way.
So I think, I think you made a comment saying you can't assume that the 15,385 is increased. I think what you said was you can't assume it's going to be the same calculation, but logically over a 24-week period, if you pay people their standard salary over 24 weeks versus 8 weeks, the calculation is going to increase.
Well, I don't think that's going to be the case. I think you're still going to get capped at the 15,385. So okay. if you have out, and we're probably saying the same thing there, but if you have an employee that you've paid 15,385 during the 8-week period, but because of the way you received your PPP loan and managed your business, you have an additional 20,000 that you could pay him over a 20-week period. I don't think that, at least as it's written right now, I do not think that that's going to be allowed.
Right. So you have a longer period of time to pay that individual what it would cover for the loan application process, right?
Yeah.
But you're not necessarily allowed to take more compensation. That needs to be kind of clarified a little bit. Yeah. And then the next point that was asked, which I thought was a good question, and if you opt for the 8-week period instead of the 24, do you go to the 60-40 rule instead of the 75-25 rule? I think the answer to that is yes, still, right?
Yeah. Yep. Yeah. And I think that's probably the next slide. There we go. So let's just kind of state the rule before we go there. But so as most of you know, we've had this 75%, 25% threshold going on since interim rule number 1, where the SBA declared that was your spending requirement. And then there was questions as to, okay, well, if I don't spend 75%, am I going to have any of the loan forgiven, right? And so those answers eventually kind of flush themselves out, and then when you get to the application, you've got this concept of dividing your payroll cost by 75%, and that becomes one of the caps on loan forgiveness. That standard has been shifted, right? So now we've got the 60%, 40%. Now, the way the act actually is drafted, it says that it says 60% shall be spent on payroll, and that no more than 40% can be spent on non-payroll items, rent, utilities, mortgage interest. Now, everything that I've read, and these are all kind of like editorial type pieces from law firms and so forth, is that that's going to be part of the new SBA guidance, right? And actually, in this joint announcement that the SBA and the Treasury Department made, they didn't get into the specifics, but they basically said we're going to be issuing guidance saying that the 60-40 will allow for partial loan forgiveness. It's not an all or nothing type of test, and that just came out literally a couple hours ago. I was checking my IntelliConnect. So now, will that be applied the same as the 75%, 25% rule in terms of dividing your payroll costs by 60%? I don't know. I don't know how that's going to operate. I would imagine it would be very similar. But to answer that person's question, I don't know of any provision within the Flexibility Act that ties the 8-week, ties the election to use the 8-week period back to the 75%, 25% for a couple of reasons. One is that standard doesn't exist in any kind of statute. Now, could someone say, well, that makes the argument a little bit more challenging because that 75-25% was a regulatory concept, not in the statute. And Bill, you just told me that the Flexibility Act, it really amends and strikes out items within the statute. But regardless, I don't think that 75%, 25%. I think that standard is completely gone. That doesn't exist anymore, and we're in a 60-40 world, regardless of whether you elect 8 weeks or 24 weeks.
Yep. Again, a lot of people commenting on the increase to the 15,000, and I think I probably confused more people with my question than the answer that Bill gave. But you have more time to basically max out the employee's compensation, right? So if you weren't able to bring someone back in the first couple of weeks, you weren't able to go past 8 weeks to pay that individual up to that certain amount. Now you have 24 weeks in essence to pay someone 8 weeks worth of compensation. That's pretty much the easiest way to kind of comprehend it, I think, Bill. So Going back, Bill, new payoff deferral. We had some questions on this as well.
Okay, so the previous deferral concepts were 6 months, could be negotiated, or you can negotiate with your bank up to a year. The new loan payoff deferral is basically the date that the loan forgiveness is remitted to the lender. So if you recall, our process here is, right, you finish your covered period, file your application for loan forgiveness. The bank's got 60 days to make a decision on that. Then they issue that decision to the SBA, and the SBA's got 90 days to get back to basically confirm that decision, and then remit the funds back to the lender, because the lender is the one that put the funds up to begin with. So now our deferral period, runs to the end of that time frame. Now, depending on what the SBA says with regard to when loan forgiveness applications can be filed, we talked earlier about they have to be filed within a 10-month period. But if they're filed earlier, and this may be a decision that you make as a business owner, right? If you want longer deferral, well, then stretch out the time in which you have 10 months, stretch out the time in which you submit your forgiveness application. Some folks may say, no, I'd rather get a decision earlier because I just want to know. I want to know for purposes of our financial statements, our tax return, whatever, what have you. But that period, right? You can do the math, right? You start extending that period if the application is 10 months away. The loan forgiveness application is 10 months away, and you've applied for your loan back in April. You can really get you can get up to a 20 months of deferral with this new process.
Hey, Bill, one of the things that I was confused about, and I thought I had understood it, and I want to be clear to ask you the question. I'll put you on the spot. I thought the way I read the guidance, it was 10 months from the end of your covered period was when the loan needed to start getting repaid. Did I say that in a way that that's the way I thought I understood it? So it was a 10-month period that you had from the end of your covered period to basically where the payments of the loan will start being required from the lender. So again, I think you've said it a little differently, so I may be misunderstanding that a little bit, but that's what I thought I read on the, when does the loan deferment in essence stop, right?
Correct. Yeah, no, yeah. If I misspoke, you're correct. Yep.
So at the end of the day, if your covered period, if you choose 8 weeks, you've got 10 months from the end of your covered period to ultimately get that loan forgiven, right, through the process, right? Yep. Or you have to start paying your lender ultimately the amount that you owe them. So
correct. Yep.
Okay.
Yep. Right. And so if you choose the 24-week period, right? I mean, you've got so now you're running that out in 24 weeks. That's roughly 6 months from the date you received the funds, right? Yep. And then you got 10 months on top of that, and then so now you're at 16 months. Now you've got 60 days and 90 days. So that's how you get up to that 20 to 21 month.
Absolutely.
Yep.
Absolutely. Yep. Okay. And then last point here, Bill.
Yeah, so the maturity date for the loans, and again, if you were following this in the beginning, it was all over the place. 10 years, 5 years, they went down to 2 years. what we read, and Frank, maybe you can kind of comment on some of the things you read, was that, and so we've got this 5-month maturity for new loans, and we've got existing loans, and I think they're trying to keep it at 2 years, but they're allowing borrowers the option to negotiate up to a 5-year.
Yeah, that's what I heard. So new loans after the Flexibility Act was released will automatically be issued with a 5-year maturity, but existing loans will stay at 2 years. And everything I've seen and everything I've read and tried to basically research is saying that your 2 years is still in play, but it seemed like they've opened a window for lenders to go in and negotiate again with the borrower if the borrower wants to try to get that 2 years up to a 5 years. It's up to the borrower and the lender to negotiate that. Yep.
And then we've got the so last piece here. I think this is the last piece. You've got the employer tax deferral, right? So that was all part of the CARES Act with regard to your employer payroll taxes. Originally they said that if you had a loan forgiven, then you couldn't defer your taxes. Then they said, well, then the IRS stepped in and said, well, you can defer taxes up until the date your loan's forgiven. Now they're just allowing PPP borrowers to defer their payroll taxes up until the date that anyone else could, and not non-PPP borrowers could defer, which is up to December 31st of this year, right? And so that under that provision, you can elect to defer those taxes, all your employer payroll taxes, until December 31st. Then you're going to pay 50% of that balance that you deferred. You're going to pay that on December 31st of 2021, and then you're going to pay the other 50% on December 31st of 2022.
Yeah, Bill, this is I believe this may be and again, this is pretty big for companies, because if once you had your forgiveness kind of understood, you couldn't do this anymore. And I think what this allows is a little bit more flexibility, but with the understanding that you still got to make payments, right? You're still going to have to make two rather, substantial makeup payments ultimately by 12/31/21 and 22. So small piece. But I think, this next slide, Bill, you and I debated what to include, what not to include. Some of the questions that still remain. One of the things I will say is there's a lot of Q&A, Bill, that's being pushed into our chat in regards to our position on the 15K versus the 46K, and whether we have misunderstood the provisions or not. Listen, and I guess what we'll say is we're not sure. Bill and I are not, in any more of a position to understand this other than the fact that we've done a lot of research to try to get educated as much as possible. We've read the act, we've read interpretations of the act to try to make sure that we're putting ourselves and our clients in a position to plan accordingly. But to this slide, there's so much that raises question that with this new Flexibility Act, that some of the questions and some of the debate, which is healthy, 15K versus 46. Why should it stay at 15, or why my position of why it shouldn't go to 46K is debating they're really good questions, and we don't know. And that's why we're hoping, the SBA is classic for dropping guidance on Friday evenings. So to make us work over the weekends, we're hoping that we get another slug of guidance on Friday that we can incorporate into our positions and help guide our clients. But Bill, why don't you go over some of the other questions here that I think we've hit most of them already, but it will give me a chance to pick a couple questions out and we can debate them.
Yeah, just before we get into that, Frank, one comment on that 15 versus 46, right? That math of the 15, goes through, the loan amount, right? The loan amount, and then the 8-week covered period. So if you kind of look at it, they gave you 2.5 times payroll. Originally gave you 8 weeks to spend it, but you also got to spend it on other costs, right? So I think what they were trying to project out, and for some it worked and for some it didn't, was that you're going to have 80. You have, again, your loan was based on two and a half times payroll, but then you had these other costs you could include. So I think they were looking at it as kind of an 8-week payroll spend, and then the balance of 20% being spent on rent and utilities and mortgage interest. And so so now we've got this new potentially this new 24-week covered period. And I haven't seen anything in the statute that basically says that you can increase the payroll to 46,000 or whatever that was. That number wasn't changed. Only that the covered period was extended to 24 weeks. Now, I certainly understand the potential argument that you could say, well, the 15,385 was calculated on an 8-week covered period. 8 weeks really, and we know what the cash and accrual kind of extended beyond that. So I can see that argument being made. I just haven't seen. There's no guidance yet, so it's hard to claim that right now when I haven't seen the SBA kind of issue anything on that. It would seem to be a little bit inconsistent with how the loan was actually derived, which was, again, if you look at it, it was kind of derived on 8 weeks of payroll. And it was 2.5 months, but you have other costs included in there. But we'll see. I don't want to. I guess I don't want to say that absolute. I don't want to give absolutes on that answer. And certainly something that we're going to monitor. But I think it goes a little bit against the intent of the act. But we'll see. We'll see where that goes. Regarding some of these other additional areas where we think there needs to be some additional guidance, we talked about it throughout this presentation. But certainly on these safe harbors. They ask for documentation, but what's going to be required? The SBA has been okay in terms of issuing guidance regarding documentation. Certainly, they've provided some laundry lists of information that's needed. Payroll tax returns and other statements. Bank statements and rental agreements and so forth. But this gets into a little bit more subjectivity. And if any of you folks had listened to any of our prior webinars, we did one with UKS, and we got into some employment law type of concepts. And I think we're going to start. You're kind of going to start going down that road a little bit in terms of trying to document, an inability to hire. So hopefully they issue something. Again, nothing yet. Let me see. Next bullet: requirement to maintain restored levels of FT and wages. Yeah. So this was kind of something we talked about a little bit earlier of just like from an FTE. If you do choose the 24-week period, what does that do in terms of your requirements with regard to FTEs? Is that going to carry forward for 24 weeks, even though you've spent 100% of your loan proceeds by week 11? Right now, I would say the statute doesn't say that the statute would be read that you would have to carry that through for 24 weeks. That doesn't seem logical, as Frank mentioned earlier, but we're going to have to wait to see what guidance comes out on that front. Yeah, this third bullet, I don't know, Frank, you want to tackle this one, the written offer on employment during covered period? I think they're pretty similar. I think we talked about that a little bit earlier. They're pretty similar in terms of that inability to hire.
Yeah, I think
or inability to rehire an employee.
Yep. Yeah, I think it just became one of those little sidebars that you and I were having, and as I was reading interpretations, mainly from employment lawyers, it became I think just making sure that I think the application kind of justified this whole rejection of a written offer concept, right? It came out as the application process came out. So, I think we're waiting on the new application to kind of make sure that we're not replacing one with the other, or if we're just supplementing for additional check the boxes and don't include certain employees here in this calculation over a 24-month period versus 24-week period versus the original application that had it over the 8-week period. So, I think we talked about that. I'm not sure if I clarified that, Bill, but I think that's where I was going with that one in the application.
Yeah, I think that's similar to the last bullet. Is the safe harbor available if activity is reduced solely
Yep.
due to compliance.
Yeah, and that was my point before. I mean, there's been some discussions as to, are they going to give leeway of state versus federal guidelines, and certain states are opening slower than others, and certain states have more restrictive guidelines for a business being able to operate in a manner pre-COVID. And does that allow the business to apply state rules into the federal regulation concepts that have been outlined? Yeah.
Right, and then and also whether there's any, is there any leeway for business owners, decision making in that whole process, right? I mean, you've got compliance requirements. The way that it's written, I don't know that there would be, but certainly that could be something that the SBA would issue, that you may have business owners that, or they may have employees that are, not willing to come back to work because of safety concerns, and how that would get handled. Some of those may be internalized, but maybe very real situations that, if those can be documented, potentially you could get a very similar type of safe harbor.
Yeah. I think there's been a lot of questions. We've got some extra time here, so we're going to try our best to kind of walk through some of the questions. Bill, we've had some questions on, what are eligible uses. We didn't really get into that here, and I don't want to get into it too much. I think I would say to people, please go back and look at some of our prior webinars, and if you have additional questions, don't hesitate to reach out to us. I think one of the questions that came in, and I think we've answered this one, Bill, is, listen, if we use all the funds now within the 24-week period, is it 100% forgivable regardless of the prior calculations of number of employees during the time covered versus last year? Absolutely not. I mean, you have an extension of the safe harbors now, right? So you still got to do your numerator denominator calcs. You still got to go through your maintaining of employees and maintaining of salary levels. It's just now over an extended period of time. Until we get guidance, that's what our interpretation is.
Yeah, I agree.
If you took less than the full amount, can you ask for an increase in the amount of the loan? I think people are, this is a good question. It's, some clients I know, and Bill, I know you and I have had this discussion. Some people have not asked for their full amount eligible because they were a little bit worried about the forgiveness versus non-forgiveness and what they were dealing with in the future. Now that they've got an extended period of time to use the money, they're wondering if they can go back and request more. It goes to another question, is if you've already had a loan, can you get another loan? I think the answer to that is no. I think, unfortunately, you're stuck with what you've decided on, and you have more flexibility in using the amounts that you ultimately got approved for. But I don't believe this opens up the opportunity to go for another loan, even if you didn't go for the max.
Yeah, I mean, they issue. It'll be interesting to see where they go with that one, because they did issue, I don't know, maybe it was 3 or 4 weeks ago. They did issue, an interim rule that basically said if you were a partnership, right, and you didn't apply, including your partner's compensation, or if you were a seasonal employer and didn't basically max out your loan, then they gave borrowers an opportunity to increase their loan amounts for, including partner compensation, for example. But it was specific to those two items. Now we've got a whole new game here, and so I would imagine that question, I think, will probably be addressed in the guidance, because I'm sure everybody's got it on their mind. Can I get more? I didn't do the run on the last set of numbers. I thought there was maybe 95 billion still available, but right now I would say no, because they've addressed that with regard to very specific concerns. But they haven't issued guidance since this Flexibility Act got passed, so I would expect it's going to be in the next set of guidance.
There's a lot of questions on clarification of the safe harbor if electing the 8-week versus the 24-week option. Unfortunately, I don't know if we can clarify it, because right now, the way the Flexibility Act is written, there is no safe harbor now using the 8-week period to June 30th. Everything is moved to 12/31. So unfortunately, until we get additional guidance, you have to go under the assumption that even if you're under an 8-week period, you don't really, you have the ability to wait because you're going to have a 10-month period, right, to apply for forgiveness. But you probably will have to wait if you need to use that safe harbor period until they come out with any guidance that clarifies this, which I think they should. You're going to have to do your safe harbors now as of 12/31.
Right, and I've got clients that have that, that fact pattern. Like I said earlier, they were already looking at ways to use the safe harbor date of June 30th, and they're getting toward the close of their loan period, and they've expended, if not 100% of the funds, over 95% of the funds, and so that plan that they established has to be moved up 6 months.
Yep. A lot of questions, Bill, on the 15 versus 46, and it's obviously a hot button. I would just encourage people to follow us as closely as possible. We'll try to get some answers on that question. I think we've kind of exhausted a lot of discussion on that and trying our best to get to the understanding that there is some ability to interpret this thing differently. But right now, I think the way we're interpreting it is you're still staying at the 15K. But again, if we're jumping through as quickly as we can through some of the guidance and some of the evaluation of the guidance. So if something changes, we'll be sure to get it out. When does the interest start accruing on the loan? That's after the deferment, right, Bill? So could be up to 10 months, right, at that point? Or do I not have that right?
Yeah. No.
Payment is 10 months. When does interest start?
Interest accrues from the date that it's dispersed.
Okay. There's a lot of questions in regarding getting back to pre-COVID business. If the industry is not able to, the industry that the company is supporting is no longer back. Someone from a sporting goods retailer saying, listen, there's no sports. Can't get back to pre-COVID levels. Does that qualify? Good questions. I think some of these are going to need to be interpreted. But I think that you have an argument there that if you can't hire people because of the lack of the industry that you're supporting being back in place, I think you can make the argument that you have the inability to get back to levels because of the impact that COVID has had on your business.
That's a great example. That's a great example of where the direct impact to that business may not be something you see in the CDC or the Health and Human Services report, right? Because they may open up, those kind of non-essential type retail shops, but certainly the business is materially impacted by the fact that there's no demand for those materials. So that's a great example, and it'd be interesting to see if I don't think they would issue guidance on that, but hopefully they do, because certainly is not not the only example. There's going to be
another individual mentions the fact that they don't really have buildings or labs to bring their employees back to. So if they have restricted access to their buildings, does that count as an inability to rehire and bring people back? Again, very specific example of the ability or the need to interpret those new safe harbors in a manner that to meet the expectation that, hey, I didn't get to these levels not because I didn't want to, because I didn't have the ability to bring them back for the following reasons, and therefore I'm claiming a safe harbor. I think it's going to be specific based on your client, based upon your company's circumstances at this point.
Yeah, I mean, there's definitely been a growing trend, right? Ever since question 31, I think the trend has been with each new FAQ or issuance of guidance or application, the trend is certainly towards making this more flexible, as with the Flexibility Act. So I think that those types of situations will be ones that there will be, if not guidance, there will be a little bit more acceptance of, but we'll have to see where that goes.
Yeah. I mean, Bill, we got another, we got a lot of, we've been focused in some of our webinars on nonprofits, Bill, and I know we've got one person asking a nonprofit question as to being a year-end June 30th, which is, also applicable to for-profits that may have off year ends, but would the loan be categorized as a liability and not as revenue? Is the loan forgiven? If the loan is forgiven in 2021, does a loan then become revenue? Some of these questions, we have a not-for-profit, Amber Tucker provided a lot of, or is trying to provide a lot of guidance in the non-for-profit arena. So I would encourage individuals to reach out to her to help kind of manage through those questions. I know, Bill, you did some non-for-profit webinars with Amber, and there's still, a question as to what the categorization of this loan will be in nonprofits because of other funding sources and interactions of how those funding sources are kind of managing the not-for-profit, underlying employees and how they're being used and how the other funding requirements get categorized in a non-for-profit, financial statement versus a for-profit. But I very, very good question. There's still other questions in regards to for-profit on classification of these loans as well. So there's other. So I guess my point being, I'm not sure if Bill or I can answer that question specifically, but I would encourage you to reach out to Amber and we can try to do our best to get you more guidance on that.
Yeah, a lot of great questions. I'm just kind of scrolling through them as well. Obviously the hot button one is the 15 versus the 46. It'll be interesting to see where that goes. And obviously that's something that we're going to stay on top of. Like I say, you can make an argument that, you potentially could get there, but it's going to require, in my opinion, it's going to require SBA guidance to get you there.
Yep. Some questions on the 24 weeks versus 8 weeks, how do you get it? Do you have to apply for the 24 weeks? If you're an old loan, we were always thinking, how do you get to the 8 weeks? Is it an automatic transition to 24 weeks unless you opt out back to the 8 weeks? Question was, hey, do I need to apply to 24 weeks because I'm coming up on my 8-week deadline? And, I think you got to reach out to your lender. Unfortunately, I think some of these answers need to be managed with the individual bank that you've worked with and saying, listen, I just don't want to lose an opportunity to go to 24 weeks or on the opposite side, stay to 8 weeks. What do I need to do to make you aware of what I'm trying to get to? I can't answer that in any other way. That's what we'll be doing with our lender if we decide we want to either stay or go to 24 weeks or 8 weeks. So. So, Bill, we still have a lot of people on the call on the webinar here. A lot of questions in regards to, if you extend your 24 weeks, can you also use your rent, utility, and mortgage for the entire extended period? Yes. I believe that answer is yes.
Yep.
I think the only thing that's changed now is you have now up to 40% of the loan you can use. And remember, it's the loan amount that you were granted, not the amount that you've used. That's a change. When it went to 60/40, it went based upon your total loan amount that you've issued, it used to be 75% of the loan proceeds that were actually used at that point in time. So at the Bill, unless I think we're 10 minutes over at this point, I think I'm going to call it a day. Thanks everyone so much. Our contact information is on the screen. I would ask that you please stay attentive to our website and our page. We try to update materials as soon as possible. If you have any questions, feel free to reach out to Bill or myself. And good luck with everything going forward. And thanks again for attending, and have a great rest of the day.